been a while since I did the, Seek ELLAvation segments just on my own. I've been focusing on rolling out the remaining Impact 26 series individuals. They've been absolutely amazing, absolutely exceptional. So it's been a while since I've sat and talked. But there's a couple of things that compelled me to come out of the woodworks, compelled me to come from behind the curtain. I'm going to talk about one of those things today. I may talk about another one later on. I don't know. I have to be compelled to talk about it. But right now, I'm compelled to talk about this one. My areas of practice as an attorney, an empowerment attorney, an attorney who empowers her clients, her community, and just customers in general with knowledge and information to help them level up in their intellectual property protection, which is copyright and trademarks, and their contract deals, whether it's sports deals, entertainment deals, just business transaction deals, or with their legal compliance in just understanding how to navigate that particular area efficiently, effectively, and correctly. That is what I do. I empower my clients there. So anytime that I hear something going on and it involves one of those three areas, I'll usually step in where permitting, also where I'm compelled to use those moments, those times, or whatever's going on to help educate individuals or to help drive in points that I've already made. Well, right now, today, what I'm going to talk about is trademarks. I've talked about this on several other, I believe, segments. I broke it down, maybe the trademark segment, maybe broke it down twice. I also wrote a book, Code v. Code, the street code versus the legal code, rethinking your business transactions. And in this book, I talk about intellectual property, which is trademark and copyright. I don't talk about patent. That's not my area. I talk about your right of privacy, your name, image, and likeness as a regular civilian or as a celebrity. And I also talk about contracts. So that's one of the other thing I may talk about later on is this issue we've been hearing about contracts. We've been hearing a lot about problematic experiences in the entertainment industry, music specifically, but it's across the board. I may talk about it, may not, I'll think about it, but it's definitely my book. Again, I have this book. It is available on Amazon if you are busy and you don't have time to read, although this is a quick read. You don't have to read it from front to back. You can pick whatever section you want to go to. They're not tied to each other. If you want to, go to intellectual property, go there. If you want to go to right of privacy or contracts, go there. But also, if you just don't have time to read, it is an audio book. But if you do not want to buy the book, I am going to share one of my mini classes that I teach on trademarks. I teach on these particular areas, which is copyright, trademark, name, image, and likeness, contracts. But this segment is about trademarks. So I will share one of my classes that I've taught regarding trademark to you, complimentary. So I want you to know the information that I'm sitting here talking about today is not for you, not to sell myself, not for you to buy anything. But if you're someone who likes reading, go ahead and you can buy it. If you like someone who likes listening to audio, you can buy it. But if you don't have any coins to buy either one, I am going to share one of my class sessions that I taught on trademark. I am not monetizing this. So none of this is about clickbait. None of this is about upselling. This is about up leveling. I want to up level you. That is what I do as an empowerment influencer, period. But in any of my platforms that I am engaging in, I want to utilize and capitalize on the moment to educate you, to take you from that ignorance to impactful. And that's what I want to do, because unless you have not been watching any television or not been on any social media, I know we heard about this trademark issue. We've heard about the uproar of Ye, the artist Ye, wearing White Lives Matter shirts during Paris Fashion Week. And then later on, we heard about two young gentlemen who different headlines have read, own the registered trademark. They own the trademark. If you use this trademark, there'll be a cease and desist. If Ye can no longer use the trademark. So the question is, and what I want to use as a teachable moment is, who owns the registered trademark to White Lives Matter? The headline says that there are owners to the registered trademark of White Lives Matter. So let's talk about that. And hopefully, after I go through all the information, you'll be better able to answer that question. Hopefully you see that I'm also coming from a place of, again, educating and empowering. Whoever ends up owning it, whatever that answer falls, I hope someone owns it and have great intentions to provide a product or service with that mark that is for the betterment of humanity, whoever it is. But that's not what I'm here for today. What I'm here for today is for you to pay attention to what you hear. And I know you probably have sources that you trust. You probably watched some of the things that was said, some of the things that were done, and you may feel like it's got to be this way or got to be that way, or this person said that, so it has to be that. I'm going to break it down for you, because your intellectual property is one of the most important assets for you to protect and for you to understand. So I'm gonna first just start off, before we answer that question, who owns the registered trademark, I'm gonna start off and give you some foundation. Again, I'm not gonna go too deep because this is not what this segment is for. I have classes for that, and I'll share that with you to go deeper. But I'm gonna give you enough foundation to be able to answer that question, and enough foundation for you not to just, go by what you hear. And you may be saying, well, I'm going by what I hear when I hear you. What I'm going to do, though, is that you're hearing from me, but I am going to corroborate any statement that I make with, one, the law. So it's not just coming from me. I'm going to corroborate with the law. If there's any statement that I say someone else said, I will read those statements from either a case, or I will, share a quick video of that person saying it, just enough information for you to know it's not coming from me and for you to be educated. All right, so let's just first start with that question. What is a trademark? Let's get this straight, because we asked who owns the registered trademark. So I'm going to read you what the United States Patent and Trademark Office says, and that's the USPTO, the United States Patent and Trademark Office. I'm gonna read to you what the USPTO says. And the USPTO says a trademark is any word, any slogan, design, or combination of these things to identify your goods or services. I do want to add in here, because a trademark is also can be a smell, it can be a sound as well, but they're given the abbreviated overview that a trademark could be any word, phrase, symbol, design, or a combination of these things to identify your goods or services. It's how customers, or we can say consumers, recognize in the marketplace and distinguish you from other competitors. So in layman terms, a trademark can be any of these things that I just named, and those things have to identify you as the source providing these particular goods and or services to consumers. That is what a trademark is. So sometimes you may even hear people say, oh, I said this, I used to say this, or such and such said that all the time, you need to go trademark it, she needs to go trademark it. Well, it has to fit both elements of the law of what trademark is. And it is, yes, a word, phrase, slogan, all that stuff, but it also has to be one that identifies goods or services that you provide, the source provide. So if I just go around saying words and I don't provide a service or I don't provide a good, then that's not a trademark. I can't just go around just trademarking these things that fit into what can be trademarked, it has to also meet the second element of that law, which is a good or service has to be provided from there. So when I say good or service, it could be any type of products that you sell. Service could be you. I represent artists. They sing. That is a service you provide. So if you're providing the service, you are the thing in which is providing the service, then yes, a word or slogan can be identified from you, or a sound from you as a service provider. But you have to have those elements met in order to have a trademark. All right, so now that I explained what a trademark is in a general sense, then let's back all the way up. Right, so we got the foundation of at least what a trademark is. So now that we know a trademark is one of these things that, identifies a source that provides a product or service, we also need to know that there's levels to this when we talk about trademarks. So if I provide a product or service, and I provide that using this particular mark that identifies me as a source providing it, I already have a trademark. I have one. If I am providing to consumers products and services, with them being able to identify who I am or where it's coming from based on my mark, I already have a trademark. With that comes protection. It comes limited protection, but it comes protection. So there's a difference. Some people may ask, well, if you already have a trademark when you provide a product or service, what is the point of this whole registered trademark? Because again, there's levels to it. So you have your common law trademark once you provide your product or services to consumers, and you have common law protection. So if I'm providing my goods or services and someone else provides goods or services that confuses the consumer within that same channel, then I have a right to file a trademark infringement, or first hopefully send them a cease and desist and everything goes great. But if it comes down to it, then I have to file. With a registered trademark, same thing. However, with the registered trademark, you are already presumed the rightful owner. So even if you have to file or send a cease and desist, the burden is not on you to prove. You already have a presumption of right of ownership. Whereas common law, if you file, you may have to be fighting to prove that you are the rightful owner. And the one who has the burden to prove is the one who has a harder fight and probably needs to have a deeper pockets. But also with that said, having a registered trademark, if someone infringes on your mark, and you live in New York and they're in California, you don't have to go to California for it. You can go to any federal law. Federal issue will bring you into any federal court. That's a whole nother thing. I won't go into it. But with common law, although it's a federal issue, if you don't register, you will have to go to that state to, where you were harmed at. But that brings me to my next point. How do you even get a registered trademark versus the common law? We know common law, you get it just merely by having this mark and selling these products and services, to consumers. Well, if you're only selling your products or service in your state, geographical area, or in your state, then you only can have a common law. You cannot apply for registration yet. In order to apply for registration, there are several things that you have to meet. One, has to be legally registrable, and then two, the strength of the mark. There's a whole bunch of other things that the examining attorney at the USPTO will look at. But one of them is that you have to have entered into what they call interstate commerce. What does that mean? If you're selling just within your state or a geographical area, you have not entered in interstate commerce. If you sell outside of your state, you just have to cross over to the border to one state. You are now interstate. You're crossing over, then you've entered into interstate commerce, whether you're physically crossing over to the state or possibly selling your stuff online to people in different states. Now you are in interstate commerce. Now you can apply for registration. So you can take it out of common law if you so choose to get that higher level of protection and then apply for registration. Outside of getting more protections when you're registered, you also just get more respect on your brand. A lot of times investors or individuals who may just want to buy your company out, it speaks volume when you have a registered trademark. It also builds value. It's an asset. There is a company that does a valuation on registered trademarks, and your registered trademarks do increase in value outside of the products and services that you sell. So there's so many other reasons. Again, we won't get all into that right now. I just want to give you the foundation that you have a common law mark and you can have a registered mark. With the common law mark, you cannot put an R behind it. So you have your brand, your words, your slogan, image, phrase, whatever. You have that. You cannot put an R behind it because it's not registered. Registered, that R behind it is saying that you went through the USPTO process and that you met all of the stipulations legally, you were approved, and you got that registration certification. Now you're able to put that R and you're able to put the world on notice that I am protected fully, legally protected fully. I'm recognized as such with that R. Common law, you can't put the R. You can put TM, you can put SM, but you cannot put the R behind it until you're actually granted certification of registration. So again, you have to meet all these legal requirements in order to do so. The USPTO registration application is a legal process. You are, one, governed by federal law in order to get through the process. Two, you're dealing with an examining attorney. The USPTO will assign you an examining attorney to process your application. So if you're going to do it, you'll be dealing with an attorney back and forth if there's any issues. If you have a trademark attorney, someone who does these trademarks, then attorney will deal with the application process. So now you know what a trademark is. You know that it's a word, slogan, phrase, sound, smell, combination of these different things that identifies products or services that you sell, and it lets the consumers know it's coming from you as the source. So that way they're not confused by other competitors if they get that same product or service. They can choose, no, this is not by such and such. It's the same product, but it's not by such and such. So I'm going here because it's this person or this company. And it's a trademark slapped on it. So I know it's coming from this person. So we know what a trademark is. And we know that there's common law. And we know that there's a registered trademark. We know there's the R and there's the TMSN. I do tell my clients sometimes while we wait on the application, we have a pending application, put that TM or SN behind your mark. What's TM or SN? TM is for a trademark if your mark represents products. SN is a service mark if your mark represents a service you provide. Put that on there to let the world know that I acknowledge I have a trademark. I acknowledge this, and that more than likely I may have a pending application. So, put the world on notice. But there's a difference and there's levels to it. If you decide to stay common law, it's absolutely fine. You can even do state registrations. It's absolutely fine. But to get that R, you expand your protection, you expand, just your presumption of rights, you expand a lot more with the R. All right. So now that I gave you the basis of that and I read from trademark law on what it is, let's just talk about what the application process is. So again, once you have a mark and you have now provided your product or service outside of your state, you can now apply for registration. If you have not used your mark yet, it's not used, so you're not just in your state. So once you use it, you have to go outside of your state. But you haven't used it, but you know that you will use it, you can also file an application. There's just two different paths you have to go down. So if you're already in use, meaning that you're selling your products and services outside of your state, you can do what they call a 1A application. That's going to go straight down this path here. You're going to eventually get assigned an examining attorney. If there's any issues, you'll all deal with those issues. And if there are issues, they're going to be legal issues. So if you don't understand them, I do highly encourage that you do hire legal counsel to get it. I've heard people say before, it's easy to get a trademark. It's easy. Oh, no, it's not that easy, because one, if you do not understand if your trademark even meet these legal standards, you're already going to run into issues. If you don't understand what doing a clearance search is, you're going to you more than likely run into issues. So it's not as easy. I heard someone say that on an interview, and I cringed. Secondly, the other path is a 1B, again, intent to use application. So you're going to go down a whole nother path. Application won't move forward. You're not going to, have an examining attorney, assigned to examining attorney, move an application forward until you go from intend to use to actual use. But at least you can file intent to use, because when you finally do use it, the registration applications are retroactive. So if somebody's still trying to jump in there and do whatever, if you eventually make it through that whole process, you went from intent to use, and you make it through the whole process and you get your R, you can go back. You have precedent over those. You have, standing over those who was using it while you were waiting on the process. But here's the thing. When you file a 1B application, intent to use, again, remember, this is a legal proceeding. We're talking about federal law here. When you file a 1B application and you're saying you have intent to use, what the USPTO says is that you have to have a bona fide intent to use the mark. So don't file a 1B application, intent to use, and you don't have a bona fide intent to use it. That is violating the rule, and that's section 1101. I'll read to you exactly what the USPTO has. So I won't read the whole thing because it's an entire, see, that's an entire thing, but I highlighted some points in here for you to get it, a gist of it. So section 1101 says bona fide intention to use the mark in commerce. If you're an applicant may file a trademark or a service mark application based on a bona fide intention to use a mark in commerce under circumstances showing the good faith of such person. A verified statement that the applicant has a bona fide intention to use the mark in commerce must be included in intent to use applications. So if you're going to do a 1B application, when you submit that application, you're going to have to sign a verified statement, or your attorney, whoever does it, that you have the bona fide intention to use it. And what the USPTO generally says here, they try to give some examples, is when you file a 1B application, you could do so when you didn't use it, but you're in the process. You're laying things out. You're in that strategic process. You're just not ready to put it out there yet, but you're going to use it because you're planning. You have everything right there, and it's going to happen. It can't be one of those situations where it's like, oh, I have this mark and I don't know how I'm going to use it, if I'm going to use it, when I'm going to use it. I'm just going to hold it so nobody else can use it. The USPTO said, no, that's not bona fide intention to use the mark. You cannot do a 1B trying to hold it just so someone else can't. And I'll get into that. There is law on that. You have the Trademark Trial and Appeals Board that people file oppositions to. It's seen there. It's just like a court, but it's for trademarks. These issues have been raised. So they do not want anyone to say, oh, I'm going to have this mark just to make sure nobody else does, and I don't have an intent to use it yet, but maybe I will. I don't know. That's not what this says. 1101 says that there has to be bona fide intentions to use it. Now, the examining attorney will not evaluate the good faith of an applicant in the ex parte examination of the application, meaning that you submit the application and on its face, it's not like the examining attorney is going to do all this investigation to see and question your good faith on whether or not you have a bona fide intention to use it. But there is a sworn statement of a bona fide intention to use the mark in commerce that will be sufficient evidence of good faith. So they're going to use that as evidence. They're not going to go try to find all this, extra, information. They're going to say, you signed this document, then that is going to be sufficient evidence. All right, so that's 1B. You have to have a bona fide intention. 1A means you're already in commerce. Now, once you begin to sell your products or provide your service in commerce to your consumers, to your customers, then if you filed a 1B, you go back and you now file an amendment. Depending on the stage of when you file that, the stage that your application is in, there's a certain type of amendment you will file. Either way, it's a statement of use, alleged amendment of use that you will actually file to show that I went from intend to use to I'm actually using it now. And now that you did that, your application will start moving right along as if you filed a 1A. You will get an examining attorney. They will go through whatever to examine your mark and make sure that, again, it meets all of the qualifications legally for you to get a registrable mark, to get a registration. So when you file an intent to use and then you come back and you do your amendment, this is now what the rule says. Now I'm in section 1104-10, use in commerce and date of use. So when you file an amendment to allege use, which is the type of amendment you file for an intent to use, you must include a verified statement that the mark is in use in commerce. You have to now go from a verified statement that you intend to use it to when you found your amendment, you have to include a verified statement that the mark is in use in commerce. It is being, you're in sales, it's moving across channels, you're doing whatever you need to do that is not just in your head, it's not just on paper, it's no longer just planning, it has now entered the channel of commerce. And you must specify the dates of first use of the mark and first use of the mark in commerce for each of the classes that you're claiming. So classes are the channels in which you're saying you're going to provide your products or services. So a class 25 can be clothing, class 41, entertainment, you can do consulting, you can do all types of things. So you pick your class and then you will, for each class, because all the classes, if you have more than one class, all the classes, some may be in use, some may still be a 1B intent to use. It's just whatever. But when you move to in use from intent to use, you have to sign this statement saying that the mark is actually in use. So those are the rules. Those are the rules. Those are the federal rules. So if any of those are violation, that could be a big issue. That could be definitely a federal issue that you don't want to happen. So now we know what a trademark is. Now we know the application process. And again, I didn't get deeply into it. You can get that later on the video, books, audio, whatever. So once it moves to an examining attorney, then the examining attorney will say you make it all the way through. There's something that's called office actions that you possibly may get. Say you overcome everything, you make it all the way through to the end, and they'll tell you that it's going to go out for publication. Once it goes out for publication, at that stage, individuals are able to come in to oppose your mark, to oppose you getting a full registration at that stage. And they could bring in several things as evidence. That's why I said clearance search is hugely important. I do clearance search very thorough clearance searches for my clients. Matter of fact, I just finished one yesterday. Today is November 19th. I'll be registering another mark for that individual, or I'll be registering a mark for that individual, not another mark for that individual. But that clearance search is very important because during the publication phase, when people can oppose, remember I told you, you have common law rights. Someone can own a mark in common law and didn't register it. So clearance search shouldn't just be done, in the USPTO database. It needs to be done. A very extensive one needs to be done because you don't know who exists with a common law right. If someone else was already using that mark and it's not registered, then they can oppose registration for your particular mark. So it makes it to publication and then opposition. And if you overcome that, you'll get your registration and your certification, and you're able to put that R. Now, that brings us back to our current question. Who owns the registered mark for White Lives Matter? You should know that answer by now. With the foundation I just gave you of what a trademark is, what a common law mark is, what a registered mark is, you should know that answer. Who owns the registered mark of White Lives Matter? If you said no one, you are absolutely correct. Now, I heard someone mention before that that's just technicality, like, not owning it, a registered mark, but having an application in there, that's just technicality. No, it's not. And I want you to be empowered. That's not technicality. That is law. Let me show you how non-technical it is. If you file an application and it has not been granted registration, can you put an R behind your trademark? Can you put an R based on the information I gave you? No. If you cannot put an R behind your mark, it's not just technicality. An application does not give you a registered mark. You can't say I have a registered trademark. Now again, if you've been using your mark in commerce and you haven't filed for a registration, or you filed and just haven't received it yet, you do have a trademark. You have a common law trademark. You don't have a registered mark. And so headlines have been reading that two individuals owned a registration of a trademark. Individuals own this registered trademark. Individuals can, send cease and desist. No one can use the slogan "White Lives Matter." And real quickly, again, I'm not going to get deep, but again, this is educational moment. That is also incorrect. A misconception is not only that you have a trademark only when it's registered. That's a misconception. You have common law. But another misconception is that when you do have a registered mark, that you stop any and everybody from using whatever that mark is, that image, that slogan, that word. That is not true. If someone uses a mark and it doesn't cause confusion to the consumers in which this product or service is coming from, you can use it. There are marks in the USPTO database that are identical, but they are in different channels of commerce. To give you an example, Delta Airlines, registered trademark, Delta. I'm flying Delta. I'm not flying US Airways. I'm not flying, what else is there? Southwest. When you see Delta, you're flying Delta. If someone makes a plane and puts Delta on that plane, that is infringement on Delta Airlines. You cannot make that plane provide that particular service and put Delta on it. You can't do it. They own that trademark in that channel. If there's things that probably are connected or related to that channel that you think is related to, an airline, they also can't use it. But now you have the Delta water faucets that's made by the company Delta. There's water faucets. They're able to use it because they're not going to cause confusion to consumers. So they're able to have that trademark as well. They're able to have it. You have a sorority called Delta. So there's we don't monopolize a word. We don't monopolize a phrase. What we do is protect words, phrase, slogan, smells, all that good stuff for the products and services we provide within the channels we provide. So I wanted to get that very clear. All right, so back to the current issue. The answer is no. No one has a registered trademark. And also the answer is it's not just technical. It's not just, semantics. We're playing with words here. No, it's you have an application for registration. As a matter of fact, to date, as I checked it to date, there are 2 applications out there. Someone just recently filed one, I believe on November 3rd. It's also a 1B, so it's probably lower on the total poll. And the reason why I say it's lower is because filing it as 1B means you intend to use it, right? So they already don't have common law rights. So you're already behind on date and you haven't used it yet. But the application we're talking about now is the one that, let me go to my screen. I believe it was filed on October 3rd. So, okay, I'm gonna share my screen here. So, again, this is not just coming from me. So you can follow along with me. All right, here we have the White Lives Matter mark filed right here. It was filed on application filing date was October 3rd. This application was filed as a 1B basis, meaning intent to use. It wasn't used in commerce yet. And when they filed the application on October 3rd, they got a status update from the USPTO on October 6th. And the status update is that this application is awaiting assignment for an examining attorney. So when you file your application, you have to wait for the examining attorney to be assigned to your application in order to move along the path, the process in which you filed. Again, if you file the 1B, it's not going to go anywhere until you amend that you're actually in use, and then you will start to move along that path. So again, October 3rd, this was filed. Status update, October 6th, that it was waiting. And then here, all right, so remember I said once you do a 1B, you have to then file an amendment that you are using your mark if you are using it. And here, an amendment was filed, October 16th. The amendment was filed that we have used the mark on October 16th, and we're in use in commerce, October 16th. First use and use in commerce are the same dates. We're here. These could be different dates. This can't be before that date though. So we're here, but it could be the same. So now we have, remember these dates, because I talked about you have common law rights. I talked about you have an application versus a registration. There's a difference. It's not technicality. An application, you cannot put an R. You cannot tell the world I have a registered trademark. A registration, you can. Common law, you can't either. You can put TM or SN on there. All right, so remember these dates. We have October 3rd, it was filed. So here's a couple of issues that we can learn from here, and especially on reporting. One, do not communicate with individuals that you have a registered trademark. Do not put an R on your intended, registered trademark until you actually have it. Do put TM or SN if you are using your mark in commerce, or if you're using your mark period. If you're using your mark period with common law, you can put it. But do not put R on there at all. Do not communicate you have a registered mark. So you don't have one. Now again, it is retroactive in date. So if someone comes after you, which I said that person also filed a application for the White Lives Matter mark on November 3rd. That person who filed a 1B also, meaning they didn't use, once they do use, their date comes after this date. So they will not be able to trump their mark at all. It comes after that date. They weren't in use. It would have been different if they were going to claim we were in use. But they already admitted on the application we intend to use, which means we weren't in use as of November 3rd. That is after this date. So that is absolutely fine. But here's the issue, other issue. All right. The first issue is communicating that there is two individuals own the registered trademark for White Lives Matter. That's an issue. That's not true. It's not technicality. Don't you do it. Just because you see it and you probably think that these are trusted sources you're hearing this from, do not communicate that or operate as such when you take your common law trademark and file an application for it. Do not put an R and do not say you have a registered mark until you actually have one. What you do is have an application. Now that's the first issue. The second issue is, as I've been talking about, are these common law rights. So this application, I'm gonna stop sharing my screen. This application has to make it through the process. There was a specimen that was submitted. A specimen is the evidence, the proof that you have used your mark. And there's different qualifications for specimens as well. There's different qualifications for that. Let's see if I have it. Okay, I do have something up. There's different qualifications that you need to submit in order to have it approved. This is why I said this is a whole legal proceeding. If you don't understand all of it, you can run into so many loopholes. Fortunately, it seems fortunately for these individuals, they have an attorney doing it, but there are still some issues for you to learn here. Even with that said, the first one I already told you, there's interviews that have been done where there's incorrect communication, incorrect headlines as well. But let me go on here and see if I can share this with you. All right, here. There's examples of acceptable specimens. So that's an example of, these are examples of what is accepted by the examining attorney for you to submit to prove that you have been using your product and service in commerce, right? So you can, use certain things. In this case, we're talking about White Lives Matter. The class that was filed was class 25, that was clothing. It was just different things listed in that class. That means that the specimen that is submitted should show that the mark is being used in commerce right now, as of October 16th, was used in commerce, and it showed exactly how it's being used. Another thing that is kind of confusing, again, I'm not going to get into it here, is that some people submit specimens that are really considered ornamental or not a mark. Some people say that they're going to file a application for registration for clothing. And what they do is print a lot of stuff on clothing. They may print these words, their slogan or whatever. That is not an approved specimen. You can have a tag. If you're filing for class 25 clothing, you're saying you're providing clothes. That's the product you're providing from this source, this brand. Put it on there. Printed words, slogans, image, that's ornamental. So that will get a rejection. Again, I'm not going to get deep into that. But anyways, there's approved specimens that you have to submit in order to move to that next stage. So on October 16th, there was an amendment filed that they were now in commerce. There was a specimen submitted. On that specimen, you will have an example of how it was actually used. And in that case, there was a shirt submitted with a tag on it, even though there was printing on the front, which was a big issue because people were saying we're going to stop people from just printing. We're going to stop people from printing this on shirts. The conversation is getting confusing and convoluted. It's not about stopping people from printing something. They're stopping people from using that mark, that registered mark, saying they provide a product or service. They're the source providing this. Now that source can provide t-shirts if that's what you provide. But it's not just about printing. It's not about stopping people from using the words White Lives Matter in other ways, channels and mediums. But in this case, since there is an amendment, when you amend, that date you have to put, as you've seen on there, the date you have to put, it has to be in use. And you're gonna have to have a bona fide statement that it's in use. And so that means that October 16th date, it had to be in commerce. It had to enter in interstate commerce. So, bona fide use, amendment, specimen brings me to my next thing. And this is a big thing for us to learn from, right? So I mentioned the information that is being shared is kind of, misguiding or misinformed, where there's headlines saying that someone owns a registered mark. But there's also could possibly be an issue where statements have been made to contradict the bona fide use statement. So that would be a question of who owns it based on those statements. Now, things could possibly change and all that good stuff, but someone can still use what has been said as of up to recently. We know that articles written sometimes don't come out until later. We know that interviews done sometimes don't come out until later. So maybe the dates that things aired or things were published was way after the interview took place. But if any interview took place after October 16th, that conflicts with the bona fide intent and with the amendment that it is in commerce, then that can be a big issue. Let me rephrase that. If their initial application on October 3rd, mind you, let me back up. This application was passed to these young men from someone else filed it. So we're not starting from where it originally did it. Someone else filed it, passed it along to these gentlemen. When these gentlemen took it on, from that date they took it on and they accepted it. If it was a 1B, then there was an acceptance and it should have been a sworn oath, a statement verifying that there is a bona fide intent to use it starting from that date that they took it. And then when it was amended saying it was in commerce, it is being used in commerce, it had to be used in commerce as of that date, not after. So there have been statements that may be kind of conflicting with the bona fide intent to use it. Some statements, okay, instead of me just saying it, I'm gonna play something right here. I'm gonna play something, just a little snippet of it for educational purposes, and also so it's not coming from me or me trying to, paraphrase what was actually said. But this that I'm going to play, I believe it was posted on originally posted on November 2nd or 3rd, but what I'm playing now is updated November 4th. Again, I don't know if this was live on November 2nd or 3rd. You can go to CNN page. I'm gonna play interview, a quick snippet of the interview just to educate you on the statement that I'm talking about. But you can go to CNN and watch the whole interview for yourself. And again, I don't know if the date is after October 16th, then this could be problematic, and I want you to learn from that. When you say you have a bona fide intent, you have to have a bona fide intent. If you communicate anything otherwise, then it's a violation of the rules. So let me see here. Okay, hold on, let me get past this. My screen share. Okay, it's up. So I don't see where it's at. Is this it? Okay, so I'm going to play this and hopefully you can hear it.
Let me start with you. What do you plan to do with this trademark of White Lives Matter?
Well, at present, we plan to do nothing. Nothing is plenty, as you can imagine. We have lawyers advising us on how to best protect the trademark. So it will not be used to hurt, harm, trigger any people. And as long as we are the people in the position to decide how it is used in commerce, we will do our best to minimize the effect that it may have on people.
So, Quinton, just explain that. So you by design don't plan to do anything with it, and that means that nobody else can. Is that the point?
At present, yes.
Again, you can watch the whole video there. So the thing that's problematic there is that that interview was after October 16th. Again, I don't know. That interview was aired after October 16th. I don't know when it was recorded. But if someone had, during the publication stage, if this made it all the way through and someone had opposition to file, that would be some type of evidence they would have to prove, show and prove. Typically, in law, submitting that type of evidence could possibly be considered hearsay. But I'll touch on that in a minute. If that can make it in, which it could, and it showed that those statements were made after October 16th, then it shows, one, it wasn't a bona fide intention. One, they got the trademark transferred to them and they didn't even have a chance to even think about how they want to use it. But if they do use it, it was stated there, if it is in commerce, we're trying to think this through. We'll think of the best way it can be used. They mentioned they were getting, legal counsel. So I know for me, not speaking about their legal counsel, what they got going on, anything. For my clients, what I try to advise them on is to do less talking about a lot, because sometimes they may be communicating, communicate some things not in the best way, not in their best interest, are a little confused. But it's best to not just jump on a lot of hype, because they can cause more harm than help. But in this case, like I said, this is why I want you to learn from this. If you submit something that a 1B and it's a bona fide use, it has to be bona fide use. It can't be, I don't have any idea how I want to use that right now. I don't know. I don't know if I'm going to use it. But if I do, then it will be XYZ. That's not the bona fide intent to use it. You don't do a 1B yet. But if you can, like that second half of the statement, you can do a 1B if you say, I am in the process of laying what that all looks like, laying it out, because I know I'm going to use it for sure. I know I am. That's the one thing. The second thing is, if the interview is after the amendment was submitted, there's a problem, because they already stated that the host came back and reiterated. So let's get this clear. pretty much your driving force was to stop other people from using it. You don't have any idea how you're going to use it. And then pretty much there was an agreement there. That's a problem. And that could be a problem with anyone who may oppose the mark, who claims that they have a rightful claim to it. This is not just about someone coming to oppose, the mark being registered, but there may be an issue that someone may claim rights to it, and that these things were possibly not done legally or correctly or what have you. So we talked about bona fide use, what's expected by the rules, bona fide use, what's communicated by what's expressed, may be an issue. Now let's go back to common law rights. We talked about that, right? Now I understand that, and anybody that watched these interviews, and you clearly seen the headline there, this mark, this application for registration for this mark was done so Ye can use it, and anyone else possibly to harm humanity. But it was sparked because Ye wore his shirts at Paris Fashion Week. To my understanding, Paris Fashion Week, I believe, happened October 2nd. So there's another issue here, because we talked about common law. You have common law once you enter interstate commerce. Now, I don't know if shirts were printed in one state, in one country, cross border lines of states or countries, but there was interstate commerce there. I don't know if the shirts that Ye wore was just ornamental, or if did the shirts come from a mark, something that he used White Lives Matter as, in which these shirts are coming from, and then he dealt with business to get these things done for Paris Fashion Week according to that mark. I don't know, but if those things are present and those things are arguable, then Ye could have common law rights supersedent to an application. So why do I say that? For you, this is why you must do clearance searches, because when you register a mark, you love a word, you like a word, and you just feel like it just fits what you're doing, and you decide, I want to go apply for registration. I'm going to submit an application for registration. And there was no search done. Someone who's been operating that hasn't registered but has been in commerce, have common law rights, can come and stop your mark and shut everything down. And that could be the case if Ye was even interested. If he's interested and he met those things to show that he used that in interstate commerce, then he has superior rights to an application, not a registered mark. This is not a registered mark. This is an application for registration. During the opposition phase, he can fight it. And thereafter, he can fight it based on having common law rights before the actual use of the registration, or the actual bona fide intent to use of this registration, and that date that reflects that. If all of that can be dismantled, then there is a big problem. I did hear an interview where the young gentleman, and again, I wish whoever the best is doing, I wish whoever the best, I want you to learn from this. Don't go by what you're watching and you're seeing and think this is how you can move. I heard individuals say that, the examining attorney's there, or he was advised, the examining attorney's there to help you along, to help you. They're there to help you in this process. The examining attorney do. The examining attorney will try to, in but so many words, say what the issue is. They will say what the issue is, right? And they hope that you can get it and you can fix it. And if you are legal, more than likely you'll get it faster than if you're a layman. It just is what it is. They hope you can, but they're not going to give you legal advice. They're not there for that. They're not going to tell you exactly, X, Y, Z. They may give you hints. They may give you suggestions, and it's like, yeah, get it, hopefully. But when it comes to an issue like this, someone opposing, have opposition to a registration, then that can go to the trademark trial and appeal board. That's totally different. And it's just like a court. And some things may make the fight a little easier than other times. I'm gonna give you an example. So there was a case, I covered this in my class. I'm not gonna go deep on this. I covered this in one of the classes, or a few of the classes. And one of the classes that I post, the class that I post for you to watch, it'll be in there. To watch complimentary, non-monetized, it'll be in there. But there was a case where it was involving Blue Ivy Carter. A wedding planner had a mark registered with the Blue Ivy, and then Beyonce and her company wanted to register Blue Ivy Carter because that's the name of their daughter. The person who had the mark opposed this registration. Now, I'm just going to summarize. I'm just going to pull out the point that I'm making now. I'm going to pull that point out from this case here that went to the trademark trial and appeal board. So the opposer to the Blue Ivy Carter application raised an argument of lack of bona fide intent. And they raised that argument based on a statement that Jay-Z made, and that, they put Sean Corey Carter, that Jay-Z made. So the opposer, the individual that's opposing this application from making it through, said that there were certain prior statements, and I'm reading the case from the case, that there were certain prior statements made by Sean Corey Carter, Jay-Z, the husband of Miss Carter, Beyonce, and father of Blue Ivy Carter, demonstrate that applicant lacked a bona fide intent to use the mark Blue Ivy Carter in commerce, on or in connection with goods and services identified in the application. So that's another thing. Whatever class you put in there, and then the goods and services you list, you have to have the bona fide intent to use it for that. So that's also a thing. You can't say, I don't know how I'm going to use it. Well, you said you're going to use it for clothing. You said you're going to use it for these specific things. So it has to be from there. You can't say clothing and then you're going to use it for, building something. You have to at least say that. So that's what the opposer said. And then the opposer points to an interview that was published in the Vanity Fair magazine. And the opposer says this is where, Mr. Carter is reported to have made the following statements. I'm not going to go through the whole thing, but I highlighted the heart of what was, the gist of what was trying to be used. Jay said they meaning registered the mark, registered Blue Ivy Carter. Jay said they did it merely so no one else could. People wanted to make products based on our child's name, and you don't want anybody trying to benefit off your baby's name. It wasn't for us to do anything. As you see, we haven't done anything. First of all, it's a child, and it bothers me when there's no boundaries. So the statement made here was, we registered this mark because we don't want anyone else trying to benefit off of it. So that's why the opposer raised the lack of bona fide intent argument. The applicant tried to come back and say, well, first of all, that's hearsay. You're trying to pull an interview in as evidence. It's hearsay. We don't want that to happen. So we are opposing that this evidence is even something that we're discussing. Let me have a look at the time, make sure I get ready to wrap this up here. But in real quick, in the legal world, when we talk about hearsay, we're talking about a statement that's being offered as evidence other than a statement of the one testifying, the one that this statement should be coming from. When it's offered outside of that person, then it's considered hearsay. However, we have something called Federal Rules of Civil Procedure that has many exceptions to hearsay, many exceptions that allows the statement to come in, written or verbal, to come in that's not being offered by the one that's actually testifying. So here the applicant again responds that the article is entirely objectionable as hearsay and cannot be cited for the truth of the matter asserted. Well, the fact finder overseeing this case at the TTAB, the Trademark Trial Appeals Board, said that they use Rule 803 of the Federal Rules of Evidence, like I told you, that you can have a statement. One of the exceptions is you can have a statement to come in to show, the state of someone's mind. You can have it to come in to show someone's motive, intent, plan, and all that good stuff. So the fact finder, this is how they held, said, yes, you are correct. We will take in this evidence that you're submitting to show that there was a lack of bona fide intent to use this mark that is being applied for registration. We will do that. You can meet that first level under an exception. However, we're gonna shoot it down because the statement that's being offered has to be offered against one of the parties of this issue, of this claim. Jay-Z may have said it, and Blue Ivy Carter may be his daughter. But Jay-Z was not a party to this trademark issue. The company that Beyonce owns is the one that owned this mark and was applying for the mark. Now owns the mark, but was applying for the mark and all that. Jay-Z had nothing to do with this company. So when the statement would have held, the statement would have been fine, the statement would have came in, but it was made by the wrong person. It was also made by someone. It says here that a statement offered as an admission against an opposing party has to be made by the party in an individual or representative capacity, and the party must have manifested or adopted that belief to be true. So it wasn't the individual or representative. Jay-Z wasn't operating as a representative or individual in the capacity of this case. And also, there was no evidence that Beyonce or her company adopted the statement of what Jay-Z said to be true. That's why that statement got knocked down. What's different in this case? So we clearly see that not having a bona fide intent and statements being made can be used to prove that, can be entered in. What's different is, in this case, the statements are being made by parties by individuals who would be parties to an opposition, who would be a party to the Trademark Trial and Appeals Board case. It's made by those individuals. So if you're someone who's submitting something and you said you have a bona fide use, or you said that you entered into commerce, make sure that everything and how you move aligns with that. So that may be another issue here. So if Ye was to come in and he has common law rights, and he want to oppose it based on those common law rights, or oppose it based on lack of bona fide intent, that's a probability there. That's a probability with that argument.
Aside from Ye possibly raising an issue or opposing the registration of this mark, aside from whoever this person is that submitted a trademark application on November 3rd, trying to overcome their office action that they will more than likely get, this phrase has been out there for some time now. I was talking about this with my sister, and she had brought to my attention, this has been some time with this particular phrase, White Lives Matter. And some will say that the phrase is a backlash or white supremacist response to Black Lives Matter. So this has been since 2014, 2015. So the question is, who possibly could have been using this phrase in a manner of providing products, services, or what have you, in a common law fashion, who haven't registered their mark? Because remember, I told you don't have to register to have a trademark, but who possibly could raise issues as well outside of those individuals? My sister brought to my attention a website that is actually up. Now, I don't know who this website belongs to. I will share it, but this website, I believe, was established February 10th, 2014. It was recently updated October 18th. But the actual registration for the whitelivesmatter.com was registered in 2014. And on this website, there is, let me share my screen. There is merch that is on here. There's donate button for individuals to donate to the website. I think it might be this. Let me see if this is it. No, that's not it. Maybe here. Yeah, so White Lives Matter .com was founded February 12th, 2014, updated October 18th. But this is the website, White Lives Matter. I don't, again, know who it belongs to. Does this belong to Civic Cypher? Was it passed on to Civic Cypher now? But it was established in 2014. According to the picture that I'm seeing, I wouldn't think so. I do see Ye and Candace Owen on here, two individuals that received major backlash for supporting this phrase on the shirt. So I wouldn't think this will be their website. But again, I don't know. If it's not, that's a whole nother issue, because again, this was established in 2014. There's a donate button here. There's the Stop the Division that they have posted. There is shop and support. You can buy all types of merch to support. Your voice matters. You can suggest a charity organization in which they donate to. So again, if this is not if this is someone totally different, then there's someone else who could possibly be in an argument if they're interested. Like I said, if anyone who has a possible argument for common law rights prior to the registration, application for registration, they will have, they could possibly supersede the application. They will have strong rights. Common law trademark is still your rights. You don't have to register. So that can be fought. Now, again, with class, because remember, like I said, when you register a trademark, it's not for you to stop everyone from using that mark in any way, shape, form, or fashion. It's to stop them from using it in the way in which you say that you are trying to protect that trademark in any channels that are closely related to how you're doing it, so it doesn't cause confusion. There's, other ways that these individuals may register the mark, although they do have merch on here. Again, remember I said the trademark is more than just ornamental. It has to be, that brand in which you are saying that individuals will get shirts from. They can be something that organization that donates to charity. It could be whatever. But again, I don't know who owns this. I just see Ye and Candace Owen on this website. And I know this website was established in 2014. So it is going to be very interesting. Very, very interesting. If no one raises an issue, it could possibly be smooth sailing to acquire that registered trademark. If people do oppose, and some people do this, they sit on their hands, they watch it go, and then they fight. And I'm sure the young gentleman, they said, I did hear in one interview that they're ready to fight, but this can become very, very costly to fight. And when the facts are there, the facts of evidence that aligns with trademark law, it makes it very, very hard. So I hope whoever decides to fight, whoever is representing them, really look at every corner, every inch of that 8x11, because just from my surface level view of it, there's a lot of opportunity here for opposition. Not to mention that White Lives Matter, as it has been stated over and over again, became a statement. Somebody made it up. Someone did it somewhere, although they say it's a statement that, white supremacists, a statement that supports white supremacy and the backlash of Black Lives Matter. I get that. Someone made it up. And it may be considered like a viral thing, just something that everybody's been using. And that makes it even tougher to register as your own too, when it becomes a fight that became a well-known phrase, viral phrase. It may be very hard. So this is not clear cut. But more importantly, again, what you do in registering your trademark or considering your trademark, this should be a wake-up call, something on your radar to let you know that it's not clear cut. So that is very interesting. So as I was saying,
I want you to walk away with here is one, owning a trademark, registered trademark is a legal grant. It's a process to take very seriously. Don't get caught up in all the emotion, hype, and people disliking or liking someone in order to create headlines to contribute to trauma. Because a lot of times when we follow media or follow sources that we think we can trust, it's misguiding us in our life. So let's just go deeper than just hearing it and getting hyped about it and trying to find which side to be on. Let's step back from that. Let us level up and look at how what I'm hearing, how does that affect me and how I may move. Again, as a legal representative, as an empowerment individual in these fields, I've seen people move the same way because how they've been misled, guided, how they watch what used to be, thought they could be. It's time to change that. So while we have this in front lines, headlines, let's learn from it. Let's learn that what I'm hearing, I need to know more. Can I really move like that? Is it right? Again, a registered trademark is more than a technical situation. It is a valid situation. It is a valid approval to put an R behind your mark. If you can't do that, you don't have a registered trademark. In this case, no one has a registered trademark. We have two applicants pending the process. Both entered as intent to use. Both have to have a bona fide intent to use it. One entered in after the other, so they're more than likely already out. They're going to get a likelihood of confusion off of action and they're done. The other went from intent to use, again, had to make sure everything that's being said and done aligned with their intent to use it when they got it. And it sounds like from what I've heard and seen, it's not aligning, but it could be, again, the dates may line up differently from when things are seen, heard, read. And then you learn that when you amend to use, that you actually start using. You start using. And if you're going to talk to anybody about that, that everything that you say aligns with you are in commerce. You're in it. You said you're in it. So anything that comes out of your mouth has to be that you are in it. And you're in it in the classes in which you say you're going to be in it. You can't register for one class and use your mark and move for a different class and say that's the class that you're registering for. Now you can move in a different class and have common law, but when you register that what you're expecting to get a registration for, you got to move in those classes in which you claim you're going to move in. Secondly, if you register for classes, don't say I don't know how I'm going to use it. You're going to use it based on the classes you said you're going to use it, right? And another thing, do not think that you can register slogans, words, phrases, any of that stuff just to stop someone else from using it. That's the last thing that USPTO wants to hear. If you want to cause a major issue for your registration, let that be your reason. I'm registering it just so someone else can't. I clearly read to you in this case, that would have been an issue. It just was said by the wrong person. And the person that was the party to this TTAB case never publicly adopted those statements that were said. So that went by, that flew, and they got that. Don't think that you can register something just because you want to stop somebody from doing it, or just because you say it. I say this, I should register that. I should file for registration. I should file. There's got to be a product or source that comes from whatever you're registering. And it's a legal proceeding, so you can do it on your own, but this is just the surface of what I'm talking about with trademark. There's so many nuances. I just gave you enough right now because of what's going on right now, that I want you to not watch that, look at that, and think it's true. It's not true. And this is not me trying to say anything, again, to hate on anyone. Ye probably has no interest in his whole common law possibilities. Probably have no interest. And that would be the irony, that a mark, the headlines are put out there that the mark is federally registered, which we already know is incorrect. To stop Ye can't use it. Ye can't use it the way he wants. But the irony is, if the mark does make it all the way through the process smoothly, it's going to be because he didn't oppose it. So we need to know that your teachable moment, common law rights do exist, and you need to do a thorough clearance search, or, I mean, you probably can't do as a layman a thorough one. You can do a search, but hire legal who does those searches, who will tell you they'll do an extensive search. Don't just hire legal. Don't just think because Esquire is behind people's name, everybody knows how to do it. Hire someone who said, I'm going to do an extensive either U.S. search or international search. Know that common law can supersede a registration application and can be the ones who oppose it. So those are the teachable moments that I want you to know about trademark. And more importantly, the overarching umbrella under over all of this, I want you to learn is stop believing everything that you hear, that you read, and stop believing it for the sake of emotion. If we're going to do it for emotion, let it be intelligence, emotional intelligence. From the empowerment attorney, empowerment influencer to you, it's time for us to level up. And again, I wish whoever the best in this situation, I hope all of it gets cleared up. Whoever gets it, I can't wait to see the product or services that are going to be provided, because you have to provide a product or service in order to have a trademark. It has to be provided. You won't make it that far. You have to do it. Even if you get the mark, it's going to, you have to show that you've been using it. You can't get it and someone holds it somewhere in a museum unless they now go back and register that mark that ties to a reason why it will be in the museum. That's not how any of this works. And I'm very surprised at some of the comments that were made, and I'm not even gonna go deep on that comment, but I'm here to tell you, as someone who practices in these fields, a lot of what's being said, smoke and mirrors, and it's dangerous for us to follow things that are being said that can put us in a bad situation. Because in this situation, if no one opposes it, that's great. But what if your situation is different? You move like this and someone does oppose your application. What if you move differently and you said things that don't align with what you said under oath in your application? So, thank you for listening to another segment of Seek ELLAvation. Seeking you shall find. The more you know, the more you grow, but the more you share, the more we all glow. I hope you have been elevated today. And let us continue to go up, because that's what we do. Elevators.